for the future, and our presenter will be Mr. Ronald Spirn. Just 2 technical details. Please put your phones on vibrate so that we don't interrupt each other. I realize that everybody who's coming to an elderly care conference needs to take care of somebody and wants to be in touch. The other thing is, the reason I handed each of you as you entered an index card is the way we are going to be doing questions is, please write your questions on the index card, mark them to me, I'll be up here in the corner, and we will take the questions via index card. If you need a pen, they should be in your wonderful Achiezer souvenir bags. Okay, so with no further ado, it's my great pleasure to introduce Mr. Ronald Spirn.
Thank you. Good morning. It's a pleasure to be here today presenting with Achiezer's ElderCare Plus event. We're going to be here all day, and we want to be as resourceful and as supportive as possible. And I noticed that among all of the wonderful presentations and vendors and providers that are here today, that a lot of the program is geared toward the social and medical model type issues that come up, caring for a parent, long distance, and very few of the programs are devoted to money. Now, the title of this presentation is called something financial planning, or planning for the future, strategies. Really, what this program is about protecting your assets or the assets of your parents or loved ones. It's about asset protection. And asset protection is all about paying for long-term health care. So I handed out these outlines, and it's pretty brief because the basics of elder law, and I'm an elder care attorney, are almost universal. New York State, New York City, it narrows down a little bit, but the needs are almost universal. So I have a limited amount of time, right, like all of us, and in about 40 minutes that are remaining, and we're going to leave the last 5 or so minutes for Q&A, we have about 35 minutes to get through the materials. And that is why the materials are not very lengthy, they're not onerous, you don't see tons of description, there are no figures, there are no dollar amounts on the outline, because the outline itself, like today, like the entire event, is meant to stimulate and to hopefully invigorate the caregivers to do what needs to be done on behalf of ourselves or our loved ones. So, the foundation of any solid elder law plan has to do with advance directive documents. You have to have the correct forms and documents in order to be able to really implement a plan of action. Now, if I'm dealing with the individual themselves, the senior, the parent or grandparent themselves, so that's one thing. However, if I'm working with, I'm okay. You want me to move forward? Tell me why. You want this louder?
No, just
because you hear me in there. Okay. You don't even need this. You could just have me. And I'll take this.
Thank you.
Okay, you got it. Then I'll have the screen blocking me. Okay, hopefully that'll work. Okay, housekeeping. So the foundation of any elder care plan needs documents, because even if I'm dealing with the individual themselves, who's to say that a year or a decade from now that person will not really have the sharpest capabilities, capacity, and abilities to do what needs to be done. So we want to see immediately threshold and foundational items that have to do with surrogate decision making. There are a lot of different powers of attorneys. There are a lot of different forms out there. You can go online, you can just download a form. But like so many other things, when we do it ourselves, it may not have what we need in order to achieve our desired results. And I see that a lot. So it's extremely critical that not only one have the form, but that the form also be drafted properly. So a power of attorney is a document that gives another person or persons the authority to make legal or financial decision-making on behalf of the parent, let's say, the person who made the power of attorney. The number one question that I get in regard to a power of attorney is, well, if I sign a power of attorney and name my daughter and son, does that mean that I can't make any decisions anymore? And the answer is absolutely not. A power of attorney is not a document that is meant to limit the principal, the parent, in any way, but it's meant to enhance the capabilities of having family members or loved ones step in and act on behalf of the parent should the time come, should the need arise for substitute decision-making to come into play. Now, I said, or I mentioned, that you could have more than one agent on a power of attorney. So if someone has children, and common to name spouses, of course, if capable, to act as a power of attorney agent. You can name more than one person at a time. You could name one person, and then you could have a successor agent after that. So there are different styles and different approaches. There are chairs, seats over here. Come on in, it's not going to interrupt me. That can be tailor-made to fit the specific needs. So again, it's really important to have someone who can guide you and show you the proper or the best ways, based upon your needs, how to have that document drafted properly. There's a document, there's a power of attorney that's called a springing power of attorney. Now, I very rarely get involved with springing powers of attorney. A springing power of attorney says that my power of attorney does not operate until such time as I become incapacitated. So we don't really want to wait for some incapacitating event for then a child or a family member to be able to act, because sometimes it may not be convenient or appropriate even, and it's better for the parent to see how that child acts while the parent is gesund, while the parent is capable of observing and participating in the decision making. So for a variety of reasons, I'm not a big fan of a springing power of attorney. Also, you need to get a letter from a physician who says that the person is incapacitated, and if you can't get the doctor, or it's not, you don't get the letter. So we try to only name as a power of attorney, an agent under a power of attorney, someone who is very trustworthy, someone who is capable, or at least knows to pick up a phone and say, let me call up the lawyer, let me call up the accountant, and take care of these issues. So if we don't have a power of attorney, and a family comes to me and says, oh, mom has been living at home, and she's been getting private pay care for the last 4 years, and she fell and she broke her hip, and she's a little Ava Bottle, she's out of it a little bit, and we never did any planning. We want to get Medicaid. Okay, we'll get into that in a few moments. I say, well, do you have a power of attorney? No. Why? Well, mom didn't want to do it. She thought she was giving up control, or we went to a lawyer, it was too much, or we're not into that. Okay, so I said, well, being you don't have a power of attorney puts us immediately way behind the 8 ball. Because now, if we don't have legal authority to act on behalf of the parent, how can I submit a Medicaid application? How can I create an asset protection trust? How can we shelter a house with a deed transfer? So a power of attorney, yes, is tremendously powerful and is capable of doing, anything practically, virtually anything you can think of, a power of attorney can do on behalf of the parent. So those are legal and financial decisions. What about medical or health-related decision making? Well, we have a couple of seats up here, gentlemen. 2, 1, 2, some in the back. We only need 2. So a healthcare proxy is another legal document. It's not a medical document. It's a legal document that has to do with medical-related issues and decision-making. And the same way that if a parent did not create these documents that we call advance directives, because the parent is giving direction to the world in advance of a disabling situation, what to do, then not only if there's no power of attorney can the family not make financial and legal decision making, then if there is no healthcare proxy, the family lacks the ability to make medical decision making. Now, we're not talking about minor decisions, and there are always exceptions, and if the hospital knows the doctor who knows the person, then come on up. Then, careful, then the hospital or the doctors are not able to act on behalf of the parent. So that becomes another limitation. So I advocate, I urge everyone, okay, people in their 30s and 40s, maybe not even in their 50s, don't think about it. It's different stations in life. People are focused on raising children and having grandchildren, and then it kind of shifts, and that's what, of course, we see. And if we don't have these documents in place, we're at a tremendous loss. And when we lose time in this matzav, in this situation, it's all about money just going up like air. It just evaporates at a rate of thousands of dollars, either a week, certainly a month. I'm astounded when families come in and they say, oh, we're paying, we have 2 ladies are coming and taking care of our mother, and it's costing us $1,800 a week. So all of this relates back to having the ability to act on behalf of our parent or loved ones. So a power of attorney, financial and legal decision making. A medical proxy about medical decision making. Now, the other healthcare related document is called a living will. A living will is a very serious a document. It's an end-of-life decision-making document that has to do with, unfortunately, somebody who is not able to survive on their own and without medical apparatus, breathing tubes, feeding tubes, artificial nutrition and respiration. All of that is in and of itself a tremendous issue that can come up and crop up in the elder care continuum. So there are 2 types of living wills for purposes of this discussion. Wait, they're taking pictures. Let me. Good, thank you. There's a standard living will, right? And there's a halachic living will. So, as you can tell, I'm not a rabbi, I'm not a posek, and I always recommend that my clients who are interested in pursuing, and of course I can prepare both, most attorneys, elder care attorneys can, leave that up to my clients and their rabbinical decision-making needs to tell me what type of living will they want. But it is an end-of-life decision-making document, so it's extremely serious. All right. Those 3 documents are, as I said, I'll just keep repeating it, are the foundational items of any elder care plan. Without those, if we don't have a principal, an individual who has complete capacity, then it becomes very difficult to make decisions. Come on in. There you go.
I just want to get over that.
I'm gonna try to get the questions at the end. Write it down.
Right.
I appreciate the break, but Okay, no problem.
You have one more seat up here if you want to sit, okay?
There's one seat over here. Okay.
Standing room only, friend.
3 years running? Not because of me. All right. Part B, under elder law, living trusts. Why am I already jumping to an intermediate, or some would say an advanced topic, like trusts, right after talking about the basics? Because the living trusts, and we're going to talk about two different types of trusts. Revocable trusts, we'll talk about those for about 30 seconds, and then irrevocable trusts, we're going to devote most of the time addressing. A trust is an agreement, and generally the purpose of the trust agreement in our discussion, in our realm, is to be funded with assets. How do assets go into a trust? By changing the title on the asset. If it's a house, we do a deed. If it's a bank account, we retitle the bank account. So assets go into a trust. A revocable trust, I'm going to boil it down very, very simply, is mainly to help a family avoid probate. Probate is the process that an individual's estate needs to go through after they die and have to distribute the assets and make sure the executor is appointed. So, the trustee is appointed. That's the basics of a trust. When it comes to elder law and asset protection planning, then we can only talk about an irrevocable trust. Those are asset protection trusts. And an irrevocable asset protection trust is almost universally, all the time, utilized in the context of doing long-term care or Medicaid planning. And when I talk about paying for health care in a few minutes, then we'll touch upon that as well. Okay. So, an irrevocable asset protection trust, as I mentioned, is an agreement, and in the agreement contains all of the provisions that the family will feel is important, of course, under the guidance and advice of an attorney. So the irrevocable trust will name the trustee, name the backup trustees. It'll say that the trust is for the benefit of the parents if they put a house into it. It says that the parents are permitted to reside in the house for the remainder of their lifetime, and all the other issues that come up. We can put liquid assets into the trust, we can put real estate, we can put brokerage accounts, and by putting the assets into this irrevocable asset protection trust, if a family comes to me and says, Dad needs Medicaid, home care services, we don't have money. So when a person puts their assets into such a trust, then they're able to qualify for Medicaid, community-based home care services within 30 days, a maximum of 90 days. It depends if you're in the 5 boroughs, or it depends if you are in the you're in Nassau County. So the Asset Protection Trust is a legal method. It complies with the federal Medicaid regulations, and it says if it's such a drafted trust, it can go into this trust, and then the assets are legally not considered available to anyone, to any creditor. And that's a legal way of sheltering assets. So if the parent is able to stay at home in the community, then that's great. That's excellent, because it works. They're not going to have to worry about any lead time, as opposed to, and to be distinguished and differentiated from, someone who needs nursing home care. So if somebody needs nursing home care, then everywhere in the country, including New York City, you have to wait 5 years. The point being that this trust is either going to work immediately if somebody needs Medicaid home care and they don't want to, even if they did want to, but if they need to shelter their assets, then this trust is the best way to achieve that objective. More about that when we get down in a few minutes to paying for long-term health care. Take a sip. Everybody knows what a last will and testament is. You have to have a last will and testament. Will the world come to an end if somebody passes away, they die, they don't have a will? No. But one never knows what issues can come up in the realm of assets, in the realm of disgruntled family members, in the realm of just having things organized, in order. Who is the executor? If the executor, my daughter moves to Eretz Yisrael, then who's the backup? So I don't have a gap. I don't have any type of separation. Well, I'm not here anymore in the example, but that the family doesn't have to deal with those issues. It's not going to fall on the person who does or does not make the will. It falls on the survivors. So a last will and testament, very, very important, and everyone, to the extent possible, should have one. Paying for long-term health care. And this is really going to be the heart of our discussion now. The advance directives and the trusts, those are all threshold items. Those are gateway items that we need to address and pay attention to before we can even get to the next section, which is paying for health care. So, I made it very easy. There are only 3 ways known to humanity that long-term care can be paid for. Now, what do we keep saying long-term care? People have Medicare. People have Empire Senior Blue Choice. People have United Healthcare, Oxford, and all sorts of insurance coverage. Well, those types of insurance coverages only cover medical care and very, very limited post-surgical, post-medical type of care. Certainly there's no long-term coverage that comes as a result of having Medicare. So Medicare will pay for hospital visits, surgery, doctors. People get Medigap insurance policies. I believe that one of the presenters today is going to be talking about those types of issues, but that's all medical care. Situations and conditions that the individual is meant to, get better from. So if somebody had surgery, hip surgery, so there's post-surgical and there's physical therapy, there's wound treatment. It could be in a nursing home. It could be at home for a few weeks, covered by Medicare. But once it goes beyond, in a nursing home setting, 100 days maximum, and there are co-pays and all sorts of moving variables, or at home, 3 or 4 days a week, 3 or 4 hours each visit, 3 or 4 weeks, finished. If the parent, if the loved one still needs care with the activities of daily living, Medicare pays precisely 0. And the only way to pay for that care, the only 3 ways are cash, private pay, and we see people paying a tremendous amount of money, and if they have the wherewithal, and that's the way they want to go, beautiful, no problem. Get a power of attorney, get a healthcare proxy, you don't know what could happen in the future. Okay, private pay. Number 2, long-term care insurance. I know that we have presenters and vendors today also who deal with getting folks situated with long-term care insurance. So if I need assistance with 2, 3, 4 for sure of the 6 activities of daily living, which are bathing, toileting, dressing, feeding, walking, and transferring. Transferring means getting in and out of bed unassisted, on and off of the couch by oneself, which I sometimes have problems a little bit, especially on a Shabbos afternoon. It's a different issue. But if somebody needs help with a couple of those items, and for sure if the parent or the person is incontinent, that's when the long-term care coverage will kick in. There are elimination periods, you got to pay your premiums, you get, okay, you could have 2 years, 3 years, 5 years. Very, very few people I see getting lifetime coverage. Very expensive, but if a person has the means, they have the wherewithal and the finances, good. So that now gets us to the third, and I'm going to have to say, in my 22, 23 years experience as a certified elder law attorney, the most common method of paying for long-term care is the Medicaid program. If you Google Medicaid, you will get 100 different hits all about Medicaid. There are so many Medicaid programs, SSI, food stamps, all sorts of public assistance, Section 8 housing, and Medicaid for the poor. And when you ride around any neighborhood you see on the sides of city buses, they're advertising Medicaid. WIC, Women, Infants, and Children. These are all different programs that go under the federal heading of Medicaid type services. But what we're talking about is very, very narrowly defined. You don't see it advertised, but it's there, it's available, and it is very much so a middle-class program. Why? Why do I say that? Because somebody who's wealthy or has the money to pay for it, okay, so they're able to do that, and they don't have to look to another means of funding. Somebody who is already living, let's say, in poverty, or how the law defines that, and they're below certain limits and levels, then in that situation, they're already going to qualify. Or they probably don't own a house, or they don't own a lot of assets. They're already on public assistance. So by definition, they have to be below certain numbers. Okay, so they don't really need it. But as usual, it's the middle class that feels the pinch, that feels the squeeze. You worked hard, 40, 50 years, saved money, didn't start sending the kids to summer camp until the mid-70s or 1980s, and denied you, and you saved money. And now that money is there and meant to be for the retirement, for a nest egg, or to pass on to other family members in the future. Well, in that situation, when the person needs the care to shelter their assets, they're looking at total depletion. And I have clients, or I've met with families that come to me because they didn't read an article in the Jewish press, or they didn't catch a flyer for an Achiezer ElderCare event, and they're uninformed. And because they're uninformed, they're telling me, oh, well, we just spent Bobby's, she had about $300,000 about 2-3 years ago, and it's all gone. Now what do we do? Well, that's a little bit of an easier case because, unfortunately, now there are no more assets to shelter. But the idea, again, is to do more of an advanced plan and less of a reactive plan where we say, oh, this is, the store's on fire, what do we do? What can we pull out of the fire? So let's talk a little bit about Medicaid as it relates to the community-based home care program, and then we're going to talk about nursing home care. So as I mentioned, anyone who wants to get community-based home care services, and we've been getting clients 8 hours a day, 6 days a week, 12 hours a day, 7 days a week, in some instances, and it's based upon a medical assessment. It's been 24 hours a day, And also, just so I don't forget, I have here today my associate attorney, Esther Levinson. Esty runs the law firm's Medicaid department, and we work with other vendors here, all to make sure that there's a continuum of care and that everything is handled as best as it can be done, possibly, so that we have the best result. And when a person wants to get that Medicaid home care, they're not allowed to have assets in their name above $14,850. Now that number is going to change come January 1st, maybe. The reason I say maybe is because I understand, and we got a lot of calls about this, that the Social Security amount will not be raised this year. And that happens on occasion, and more so in the last several years. So it could be that the government isn't going to raise it very much. But that is the asset or resource limit. A person can have a house and up to $14,850, and they can qualify for Medicaid home care services, and that's it. We'll talk about the house in a little bit, but that's the basics to get somebody on community-based home care services. Yes? Oh, I thought you were talking about the 5-year Medicaid look-back.
5.5.
Why not? That's next. So let's now talk about the nursing home Medicaid program. So the nursing home Medicaid program, as the name implies, is for chronic care. It's for long-term care. It's not at home. It's not in the community. It's not at an assisted living facility. It's only going to be in a skilled nursing facility or nursing home. And in order for a person to qualify for that type of care, they also cannot have assets greater than the $14,850 threshold, but there's a much more difficult test that has to be passed. And that test is the 5-year look-back period, where Medicaid says, show us all of your financial statements going back 5 years, 60 months. And what are they looking for? They're looking for the money. Has money been gifted or transferred out of your name? And now the government says, hey, you can't give away money like that, $100,000, and now expect the government to pay your bill. You get the $100,000 back from your kids. Hopefully they have it. And you spend down the $100,000 and then apply for Medicaid. Well, that doesn't really need to happen precisely like that, but that is the major concern when it comes to doing Medicaid nursing home planning. Now, I don't have anything on here in great detail, but we can address the eligibility issues. We can address spousal refusal. And spousal refusal mainly is a device, a legal device, that enables a couple to do greater planning than if it's just a single or widowed individual that is looking to do the planning. The last item I'm going to touch upon, and then we'll turn it over to some Q&A. And again, if you have those index cards, or if you need a pen, you could borrow one, to write your questions down. Hopefully it's on what we're talking about. If it's a specific question, then after, I'm not running away, I'll be here all day. You could speak to me, you could speak to Ms. Levinson, and we'll answer if you have a specific question. But if it's a general question, okay.
Just want to add one thing about the questions. If you have a question that you want to ask privately, you just want to leave your contact information, just put your contact information on the card with the question, or I do not read my question. And we'll happily forward it to Mr. Spirn in his office.
Right, and no Social Security numbers, please. Okay.
Mother's maiden name, credit card number?
Right, forget it. You kidding? Okay. Pooled income trusts. I told you a few moments ago that the resource or asset limit is $14,850. Well, there's also an income limit, and that monthly income limit is $840.
Right.
But in New York State, we're very fortunate, and there are some vendors here today who are the administrators, thank you, Esty, of a couple of pooled income trusts. And a pooled income trust basically says if you have income in excess of $840, then it's going to go into a pooled income trust. It's not the irrevocable trust I was talking about. It's not a trust for a house. It's not a trust for a brokerage account. It's a trust for excess monthly income. So if a person has $1,840 a month income, and they're only allowed $840 a month income, they have an overage of $1,000. Thank you. That $1,000 under normal or other circumstances would go to Medicaid. It would go to the home care agency. But with a pooled income trust, you're able to take that $1,000, put it into, on a monthly basis, the pooled income trust, and we work with several of the different pooled income trust plan administrators, depending upon where you live and other circumstances. And the money is then directed by the family what to pay. If they're living in an apartment, you pay rent. You're in a co-op, you can pay the maintenance. You're in a house, you can pay the real estate taxes. Food, cable, cell phones, whatever, a cleaning lady, anything like that. They're not going to really quibble. And I asked one of them, they said that they will also pay post-mortem for a funeral. Yeah, oh hell. So that's now what I hope is really a about 37-minute glimpse into what I do, what we do on a daily basis, and help families shelter their assets, make sure that they have the right legal documents, and basically want to make sure that people are able to do this and forget about it and never have to look at it again. Okay, so let's get some of those cards. Pass them up, please.
If you have questions, pass them up. I handed everybody as they walked in. I handed you cards. Okay, if anybody wants, could you be the monitor, please? Thank you. Okay. Okay. Okay, any more? So just we get the first round of cards? Oh, you'll cross it out and write on the back. Okay. Okay, I'm in no particular order as I get them. Can a family member, ladies and gentlemen, this may be your question. Can a family member be in charge of the excess monthly income for a pooled trust?
Well, I'm not sure precisely what the definition in charge means, but certainly will direct and determine what bills will be paid. So that's as close as you can get to being in charge, but you can't have actual access to the money and you're not paying those bills. That's what the pooled income trust does. But the family tells the pooled income trust what we want to spend it on.
Okay.
Who distributes it? I didn't understand. I don't think
The pooled income trust,
Okay, and who takes care of that?
the pooled income trust plan administrator. They have an office. They have people who do that. But for our purposes, they will pay the bills with that income overage, so there's hardly any loss of monthly income. Yes?
Okay. Why create a pooled income trust if you already have an irrevocable trust?
Because an irrevocable trust, again, is for real estate, bank accounts, brokerage accounts, other type of financial assets. A pooled income trust is going to only address the exit that we're talking about here, a monthly pooled income trust for the excess income. It's two separate entities completely.
What happens to the money left in the pooled income trust after death?
Whatever is not consumed by the pooled income trust is going to remain with the pooled income trust, which by law has to be a listed charity. It has to be a charitable organization. So you'll see here today, OL, Lifetime Care Foundation, KTS, Keep Them Safe. And there may be one or two others that are here, and they can answer your questions about those mechanics.
Okay. Power of attorney with two people. Must both and or either make the decisions?
Depends how the parent wants to draft it. Sometimes we do see that the kids, let's say, or the agents are attached at the hip, and they need to act in concert. Other times we see, oh, she lives in Lakewood, my son lives in Flatbush, so we don't want them to have to sign every check together. Remember, more than the relationship, more than anything else, the individual who is being named on the power of attorney's trustworthiness is paramount over all other considerations.
Okay, is Social Security income over $800 part of the payment that should go into the pooled income trust?
Yes, $840, everything
Okay.
above it, Social Security, pensions, IRA distributions, annuity payments, sometimes long-term care insurance payments. People end up with a policy from 13 years ago that's covering $150 a day. Not enough. Now that's constituted as income, so
Okay, along with the I think we're all going to remember these numbers. $840 limit is for home health care only or nursing care also?
home health care only, nursing home care, $50.
That's 50.
That's how much they let the nursing home, the person on Medicaid, keep.
Okay.
The-
A month.
Yeah,
It's monthly.
the thinking being, you got all your food, electric, everything is laundry. You have no costs.
Okay.
Snicker bars.
Exactly.
Okay.
But
I'm trying to organize it somewhat. Okay, on the community-based care for Medicaid, do they also look back 5 years?
No, on the community-based Medicaid, they look back.
1 month in New York City and 3 months in Nassau and Suffolk.
Okay, is there,
Jersey, that's a different conference. No, I don't know, it's different.
Okay.
It's different.
Westchester, do you know?
Don't know Westchester.
Okay, is there a look back on home-based health, on home-based care?
30 days in New York City,
Okay.
90 days Nassau, Suffolk County.
Okay, these were some questions about the trust. If you put your assets or money into an irrevocable trust now, is there also a 5-year look back?
Absolutely. Once a person transfers assets out of their name, whether it's to kids or to a trust, there's a 60-month, 5-year look-back period.
So would it, I'm going to ask a question just following
Please.
up. Let's say today, or 5 years ago, 4 years and 11 months ago today,
Mhm.
I created an irrevocable trust.
Right?
And today I have to go into the nursing. I have
Right.
to go apply for Medicaid.
Yes.
It pays for me to pay privately for this 1 month so that I don't have to do the look back?
Absolutely. I mean, in
Okay.
that type of an example, that's easy. But some people come to us a year into
Right,
it.
okay.
Much more challenging.
Okay.
Good.
But, okay. If the parents agree and transfer their funds to a child, is this legal, in quotes, for the 5-year look back, meaning 5 years later?
It's legal to do whatever one wants with their money. There's nobody looking over anyone's shoulder. You could do whatever you want with your money. Is it legal for Medicaid? I think what you're asking is that going to cause any type of penalty period? And the answer is yes. 5 years, child or not. If the child is disabled, if the child lives in the same house as the parent, there are exceptions about that house. Again, we have to sit down and explore and examine the details, the pratim, the individual circumstances to come up with the best result.
Okay, I'm going to leave this for last because I think it's a
Okay,
good ending.
sure.
Okay, if you divorce, what happens? What's the responsibilities?
That's a loaded question. In terms of
You
what?
have a lovely wife, okay?
Yeah, right.
Okay.
When a couple divorces, like all other legal issues, they're no longer legally responsible relatives to one another. There's no more in sickness and in health or richer or poorer. So they're completely... Now, unless somebody's saying, no, we really love each other, but we're getting divorced, wink, wink, nod, nod, in order to qualify. So... it's a problem because when people divorce, what happens? You have to divide the assets. So it's not really helping out, but again, that's a very,
Can
very...
a trust be divided at divorce?
No. Once, wills and trusts in the context of a divorced couple, a dissolved marriage, are nullified.
Okay.
It has to be.
Irrevocable trust is nullified?
Like that, as it relates to a spouse at the time. It has to be redone, and that's why it's never a good idea to put assets directly into a child's name, because a trust doesn't die or get divorced or get into a car accident. But kids, unfortunately, like all other people, could be in a car wreck, declare bankruptcy. So if a parent gives their assets, money, 50 grand or 500,000 to a child or children, that's ill-advised. We don't do that.
One final question, and I just want to tell you that Mr. Spirn will be repeating the session, not the next session, but the session after this. He's also available throughout the day for personal questions. There was somebody who handed one to me on a card. I'll give it to you. The final question, what documents do you need when you come to visit the elder care attorney?
I tell families, whatever you have available, meaning if you've already done powers of attorney and medical proxies, your last wills and testament, if you have a copy of the deed to your residence, a working knowledge of your assets or your parents' assets. We don't need statements on day one. We just need a rough idea. Are we talking about people who are very modest, people who have some more means, so we know, again, how to properly tailor and craft a plan for that family.
Okay, I want to thank Mr. Spirn. You really been a great friend of Achiezer from the very beginning. Okay, and if you have any garbage with you, please throw it out. This is an extra sheet, yes, okay.